Okay, I'm confused as to what we're calling which case page, so I just want to make sure.
Okay, the first page where they make their
citizenship, it's like a fraud part and then an economic devaluation part.
Right. Okay.
Then the second page, which I guess I'm going to call gender, remedy. Then all good? Citizenship, our argument is that Morrison's economic essentials prevented Congress from passing more legislation to ensure equal economic citizenship. That Dresic and McKinnon, these new acts are necessary for a democratization of the economy, which politicizes and prevents institutions from taking away rights that reject this new robust Republican citizenship is the only way to keep the government accountable and avoid dangerous pitfalls that could have government ignoring ecological disasters, so many nuclear wars and letting recessions consume us. There won't be much chance to survive. That's found when its largest impact had magnitude of the world state, and they have not tested the impact level enough line by, and they say we perpetuate this false citizenship. That's not true. Professor Harris makes a distinction in terms of what types of citizenship we provide. And economic citizenship is different because it allows people rights to be able to choose. Our white evidence goes further, says this economic individuality allows people to determine the boundaries of their own life. Their next argument says that we make citizenship meaningless because we have money, but our Dresic evidence says there's a strategic reason why we need to do so, that we need to create this economic citizenship. Our entire half, as Professor Harris evidence is specific to this form of economic citizenship that would not happen if we do not use this commerce language. Next, they say that we enhance conservative government. Bauman evidence is better, just says that when citizenships are able to hold the government accountable, they prevent these conservatives from doing it because they have to answer to their citizens. Their next argument is universality, but some exclusionary citizenship and the pursuit for citizenship is inevitable because of issues like immigration. Next is that social citizenship now not unique impact. Next is we rupture the exclusionary nature of citizenship by politicizing the economy and opening up government to end exclusion. We make the wall of separation more permanent by politicizing the economy. That Zizek here's more evidence economic citizenship is encompassing and different from what your linked arguments are talking about. Professor Harris in 07. The idea of economic citizenship plus economic freedom from the category of civil citizenship, economic security from that of social citizenship, turning them from substance to something else into basic measures of human dignity, breaking from the category of social citizenship. It offers more encompassing notion of citizenship that captures the civil's rights and obligations to daily struggles for the right to economic well-being with capital. You can participate more fully in the democratic societies. That answers the last argument too. Gender. As not violence is getting worse, so we can totally meet the second win a turns case argument. They say that women all will be paid less. Or Johnson have said that changing the language of the court will immediately solve this argument. Is conceded. It is the reason why we saw fast on the counterplan. Next argument is Resnick argument says that we allow the Congress to pass new legislation that allows them to engage all these things like payment disparity that actually states to sites when we want to extend next to trade-off, but they can't provide citizenship, which means citizens outweighs that's extended on the voting. Our first round, the one to see the Martin evidence says that these states are failing now, and they can create as a national problem. Resnick says there's a strategic reason for a national solution because it highlights attention, forces people to act, and there's a reason why the states would be able to solve now. They say creates racism. This is not unique. Status quo criminal law will already have this perpetuates this. Additionally, we change the stereotypes by having different images. That's our goals for evidence. Describe how the remedy would actually be. Additionally, we change this because it says that everyone is regarded equally as citizens. Just what's happened additionally there's a chance to rectify equality outweighs. That's our West analysis. Now they say legal stereotypes, but our whole ask about breaking down these stereotypes in West says this has to come from the court because the court has to answer equality questions. That they have an obligation to do so because that is their job. And the U.S. Supreme Court now they say Reagan's a half without a job. His articles written before Morrison doesn't presume the simple argument from 1999 or half is about more than the remedy. It's about changing the language of the court and greenlighting Congress to be able to do more and changing the language of the court. That's their Johnson analysis. That's explained above. Now they say that we exclude people as answer on citizenship. Why economic citizenship is more inclusive. Now they say hierarchy's right, but this is the status quo. Criminal rights are valued more than private rights. It's inevitable. Government says they recognize these private acts as necessary to be able to change attitudes. They say that they say that the remedy, or they say that the remedy ignores the vast majority of evidence. Both our analysis is better. If I call it remedy will uniquely be different than all explained above. Now they say we exclude women of color. The Morrison article concludes they need the law to be able to change. Additionally, under the remedy, they can sue for legal fees. Additionally, Goldfront says that making the national problem changes attitudes of all points back to the people that were racist are no longer racist. Now they say over focused, but our efforts are not just changing one court decision. It's about greenlighting Congress and letting do more. Reason why we focus on Morrison. Additionally, our reason why we focus on Morrison is the language of the court needs to be able to change. That's Johnson evidence, which says that when the court acknowledges that gender is a substantial problem, then it will immediately end discrimination. It's only evidence. I'm finding evidence. Counterpoint. First, we saw all the democracy links to the plan. Yes, the court gets out of the way for the Congress, that they have to defer to the Congress in the future. We saw all the reasons why the Congress would be good. Next is that the plan is essentially surrendering in the fight, collapsing under the pressure of the Congress, because our Western government says that they will not pass these legislation. The court will have to uphold next argument is permutation. Do both next arguments. We solve their congressional supremacy. The arguments as far as leasing and resting arguments that we will now defer to the Congress. So we solve all the reasons why congressional supremacy was good. Additionally, the plans keep themselves for these quality questions need to come from the court. This is all explained in our West analysis. Says that the Supreme Court has an obligation that you should find yourself as a Supreme Court judge who needs to have a stance on gender violence. Next argument is conditionality. Is bad our interpretation of controversy functionally dispositional. The subject ability shift and negative sound plan. Otherwise, it destroys Afghan multiple worlds, cause activating multiple world uniques, which is completely abusive. It's unpredictable forces. The double and makes Afghan uniques linked to the world of complement and status quo and approach strategy. Time to reading cards and each word while pockets pick what they want. Time strategy, make negative far spread that each beta and teaches bad apathy. Real world policy makers can't suggest from their policy fast and pace far spread so may justify that conditionality. Just like multiple severance and nutrient interpretation. This is an independent voter for reasons of equity and fairness. Next. The Supreme Court's factual basis of Morrison needs to be able to change to be able to end the economic evaluation of women, McLean, and OO. This nation is suffering from long enough for the history of sex discrimination, interpretation, statutes based on the factors with respect to capacity, roles of men and women, perpetuation and bodies. The Supreme Court so uses both fact law, men and women's justified from letters of Supreme Rachel of similar attempts to facts include rarely uphill law of nature and creative to define women's proper role and destiny and concurrent court's assumptions. And extend our right analysis, this evidence is on point that the reason why the solution needs to be able to come from the Supreme Court originally held that women were commodities that could be bought and sold, that we need to be able to change the court's language to be able to value women as producers in the economy in order to have them give them complete and equal citizenship. Like Sarah talked about, next argument is more to reaffirm the new state action doctrine, further mentioning institutional racism different in Article 6. In 2000, the Supreme Court in Morrison reaffirmed the court's cases cannot include your American Pearson's court held Council Clause did not provide authority for Congress. Congress is not empowered to regulate private Congress and the field to the Council of Morrison when judicial use for congressional life and plan for based on discrimination. The court's message to the public was that as long as state or agents cannot act direct purpose, the court, the federal government, the whole would turn upon identified violence. Morrison has brought a bad law Supreme Court doctrine that shaped a racially hierarchical society. Morrison will face continued failure state action after the effectuate the court's decision to highlight the continued urgency of adopting new state action rule. And only by embracing the shared common humanity without the state action doctrine can we change the system around us and engage or request dehumanization, nuclear, or Reynolds 94. Critical humanism gained courage away in the world is more afraid of connection with each other, change direction, modern Western injustice, society takes brink of nuclear disaster, a complete discovery from human bound thrives as well, bring the mystical human bound size, compassion, and variety of patches from meaningful injury. Only when the suffering of the firm suffering can be found way challenging to humanize, so smart, and change the needs of institutions. Only when the deep human connection to yourself and others becomes conscious can be effectively tried to act race and sex and social discrimination. We must speak, make, and act in ways technology and actualize our common humanity state action environment, be the stars of the primary excellence, source to create the needed reformation of our social economic community, encourage so-called privacy mix. And Morrison messes with scales of balance, power, straight set democracy, Jenny Brasico off. Lopez and Morrison addition to parts of the rules while the dangerous shift and balance power from the Supreme Court. The single most important Unified Chief Council of the Supreme Court will defer the absence of Congress of the Supreme Court to renewing Congress violence for judicial deference. Additionally, they're going to make the arguments they solve all of our because they fiat the fact that the Supreme Court has to defer to Congress. That is not true. Because they will not force because our fiat of the Supreme Court to defer to the Congress actually is the Supreme Court actually deferring to the Congress and not just sort of the Congress taking the power away. Next argument is Congress powers have to come to the court to create clarity throughout the one. Once the changing norms for the range for election, Congress made our regulators and century regardless of exclusive power states that expands Congress power to involve judicial interpretation of President's Congress clause and formal money constitution authorizes great pension powers. The Congress clause as nearly are usually thought to have authorized the ultimate expansion of personal power. Next argument is that Morrison prevents congressional action. Nothing to one. Any future time Congress will advise right Congress to step around under Morrison. The interpretation is most likely follow justice after Morrison Congress follows that national standard on the Congress clause. This evidence proves that they would functionally destroy us being in the leading part of their democracy. Next argument is the emerging democracies founding the United States independent judiciary as milestone for just accountability of force. Many governments have adopted state bills from the Philippines to South Africa. Some countries such as the transition to stable democratic forms of government means a strong independent judiciary which democracy has consistently the United States Constitution provides some framework for the independence of the judiciaries. It's absolutely to strong independent judiciaries but without stable and democratic democracies. That's good.
Okay, first question, state action doctrine add-on. The state action doctrine is based on the 14th Amendment and the plan rules on commerce. How do you solve this?
The Ugarty card we read talks about why the state action is just the Supreme Court doctrine in
this
regard to
card
preventing
says
action against private cases.
Right, this card says The state action doctrine to effectuate the purpose of the 14th Amendment, and the court's decision highlights the continuing urgency of discarding the old Reconstruction cases and
Yeah,
adopting
you're
new
not
state
reading the
action rule.
part that
Why
is
does your
at
plan
the top of the
overrule
card.
the court's Reconstruction jurisprudence?
All right. Middle of that card simply says that Commerce Clause is a critical component to this because the Supreme Court always uses Commerce
okay.
Clause to enforce these questions.
Hold on, I have a question about this, because the top of the card does indeed say Commerce Clause, then you have an it continues, and then it starts talking about the state action doctrine. Is it your contention that the Commerce Clause is related at all to the state action doctrine, other than the fact that they were both addressed in
The
one?
Commerce Clause is used for the federal government to be able to pass things like private action requirements.
What?
Additionally, the link we are reading for the
Okay,
Kentucky evidence is specific to the stance that Morrison
Okay,
had in
cool.
terms of entrenching
So
state
why doesn't the
action.
counterplan solve this?
Because the counterplan does not have the Supreme Court overrule Morrison.
Okay.
Specific to the doctrine that the court entrenches,
alright.
says that it returns
Cool.
to the civil rights cases of the court.
Okay, you read a predictability add-on, did you read an impact of that?
Did I?
Yeah, a clarity argument. Did you read an impact of that argument?
Oh,
Or-
no, the source card is just about why the economic rights need to come from the court. Is the reason why I don't know.
Which part of
Are
the
you talking about the
trust
trust card?
Yeah,
Yeah.
you made some argument about clarity, I'm just wondering, this is not like a BizCount add-on?
No.
Okay, cool. You also made one permutation that's permity both, is that right, or did I
Yep.
miss another one?
Nope,
Yep.
just wanted to vote.
Okay, cool. All right, you read a card in the counterplan which indicates that we have to overrule Morrison. This evidence talks about how the court was evil in the past and talks about decisions like Bradwell v. Illinois and Mueller v. Oregon. I don't understand why the plan changes the fact that the court uses evil facts about men and women and why the counterplan doesn't solve this better.
Because it doesn't force the court to entrench a new jurisprudence. This is exactly what a Resnick argument is
What do you
talking
mean,
about, going
force
through
the court?
different-
How does the counterplan have forced the court to entrench a new jurisprudence? We read evidence which
Because the
indicates that
Congress
this is
takes
still-
an action and you just take away all power from the court. That's different from the court saying, hey, we messed
Okay.
up, we are going to change our attitude.
Is it your argument that after the plan, every Supreme Court justice will suddenly love women? Seriously, don't you think it's a little more complicated than that? Isn't the history of discrimination through the Supreme Court indicative of the fact that one case is not
Yes, but the
sufficient?
Resnick card, along with that card, sets up the fact that because the court has held that women could be commodities, they could be essentially
Right.
viewed as property, that unless the court takes a different stance, that instead of being
Yeah, right. That
commodities,
evidence
they
says
could
that the
be...
court should change, but what evidence is there that the court wouldn't continue to just subordinate women on other grounds, like Section 5 of the 14th Amendment, or
That's
preemption,
the
or some other
durability
grounds
of
like
our
that?
fiat. I don't...
Well, I understand that you feel that there's a civil remedy, but do you have any evidence that this would actually spill over to change
That's
the
the
attitudes
Resnick
of the court?
injunction evidence.
Okay, can I see the one I see?
Sure, we have them.